Thank you so much for joining me today. I really appreciate it.
Thank you for having me.
Can you share your name and a little bit about your organization?
Yes, my name is Lizzie Johnson. I'm the managing attorney of older adults with Community Legal Services. I've been practicing law for about 20 years here in Florida. Community Legal Services, we are a no-cost law firm because we receive federal, state, and county funding to provide free legal services for residents within 12 counties of Central Florida.
Can you briefly describe your passion for working with older Americans and vulnerable populations?
I love being a voice for those people who don't have a voice. Often, people who are members of a vulnerable population, whether they're older, whether they're disabled, a youth, they often have trouble navigating the legal system. So I get to help them navigate the legal system, and sometimes I actually get to help them by being their voice when they can no longer provide the voice for themselves.
How did this become your focus?
I started here as a prosecutor in Orlando, and then I saw a position open with Community Legal Services doing consumer law and also housing. Eventually, somehow I wound up really working a lot with seniors. I have always worked with seniors. And so for the last 15 years or so, I want to say they've been at least 50%, if not more, of all of the cases I handle.
Why are advanced directives and wills essential for everyone, not just the elderly?
Adequate legal planning is essential. Unfortunately, a lot of people they plan for retirement, but they don't plan for catastrophic illnesses. They'll plan for death by getting life insurance. But about 40% of the population throughout the United States actually have an estate plan. And that's really sad because I answer calls all the time for people who don't plan for life. They plan for death, but not life. And so, therefore, they may have a traumatic brain injury from an accident. They may be a stroke survivor. They may have Parkinson's or some other significant illness, and they don't have an estate plan that incorporates documents other than a will, if they even have a will that's even current or even valid.
What are advanced directives and how do they empower individuals to maintain control over their medical decisions?
An advance directive is that's a great question because an advance directive is a written or oral statement outlining the healthcare treatment you want or don't want. A lot of people I find have a will if they have one, but they don't have an advance directive. And under Florida law, which is under Florida Statutes Chapter 765, advance directives are three things. It includes either an anatomical gift, or we call it organ donation in the community. It also includes a designation of healthcare surrogate, and it also includes a living will. Those three things are considered advanced directives under Florida law. It does not include a DNR or a do not resuscitate order. That is something separate, and that's often found under Florida Administrative Code, and only a licensed physician can issue that form after consultation with the actual patient. So that form must be signed by a physician and the patient for it to be valid in Florida.
Can you provide an overview of wills and the role they play in estate planning?
The role of a last will and testament really it speaks at death. So basically, it is a written legal document that's executed by the testator, a tester strix, during their life while they're competent in the presence of two witnesses. To really be valid and it really should be a self-proving will. So that way it's executed in front of two witnesses and a licensed notary. And that is even better. And basically, you can pre nominate or pre select who your desired heirs. You can appoint your personal representative, or in other cases, they call an executor. You can appoint your digital assets fiduciary. You can outline what happens to your remains after death. You can also go ahead and say how you want your assets or your stuff distributed when you pass away. It's very important for people to have a last will and testament because it can avoid a lot of legal fees. Some people have a trust. However, we're finding that more and more people, for some reason, are not funding the trust. So therefore, those assets are still out there lingering. So it's important to have a pour over will to really protect yourself and protect your family, like your surviving spouse or your children.
What are some common misconceptions or myths related to these legal documents that people should be aware of?
One of the big ones I see is that people often used to tell me over the years, they were hesitant because they believe that when they do the will, they're going to die. And I believe that everyone who's an adult, and that's in Florida, the age of 18 or older, if they're competent, they should have an estate plan. I also assist people with probate. So you have young people who pass away in car accidents or weird illnesses like a asthma or during COVID. And then you also have people who don't pass away, but they survive and they're not themselves and they lack capacity. And because they didn't have any legal documents, they now need a guardian. So an estate plan is essential to everyone because the main goal for everyone is to age in place, but not having those legal documents may prohibit you from aging in place and someone else being appointed to make those decisions for you. And it may not be your unmarried partner. It may not be your sister who's your best friend. It may be your estranged spouse or your estranged child who's making decisions that's contrary to what you would want.
How does Community Legal Services of Mid Florida assist individuals in navigating these legal documents at no cost?
In our office, we have several different methods on how we help them. We have a medical legal partnership at several local hospitals, including Grace Medical, where we have staff that's on site who can help draft those documents. We have a pro bono panel because of federal funding. So we have, I believe, about 200 or so local attorneys throughout 12 counties who assist or volunteer. And often they will help with estate planning. About every quarter, pro bono, they host a legal estate planning clinic somewhere within Central Florida. And of course, this is all free. And of course, with older adults, we also draft those documents for anyone who's an older adult through our older adult programs.
Can you share an anecdote or a case that highlights the importance of having these documents in place?
Yes. An elderly couple came to my office because unfortunately during COVID, their child died, not from COVID, but from some severe asthma attack. She was in her early 40s. She had a minor child, which is not uncommon for me to hear, and she didn't not have an estate plan. So of course they could not apply for benefits, death benefits on behalf of the minor child because they needed legal documents so that they can become the legal custodian so they can apply for those benefits and even apply for his the life insurance through her former employer. So we had to assist them with that. And so we assisted them to get custody of their minor child, a grandchild, and then also give them advice on how they can navigate through getting the life insurance and also applying for Social Security benefits. So that's why I say having those legal documents is very important. In their case, it was they were very lucky. The father of the child was not going to contest custody and had enjoyed the family and agreed that because the child lived in Florida and even though he's very active in the child's life, they felt it was better not at this time to remove the child from their school and their friends. But that could have been a big problem if the father didn't agree because no one had an estate plan where they can voice what will happen to that child or what that parent preferred to happen to that child because even though it's a testamentary statement, it would get great weight in court because it's your voice stating what you desired as that parent, as the mother, to happen if you were to pass away.
How can our viewers get involved, volunteer, or benefit from your services?
Yes, we are always looking for volunteer attorneys, paralegals, realtors. We enjoy volunteers. So if anyone wants to volunteer, they can always call one of our local offices. We are always looking for donations because we are a nonprofit 501c3 entity. So therefore, we use those donations to help serve the community. That means there's more cases that we can take, or we can host more legal clinics for the community. We're always looking for volunteers to do other things, such as review maybe some of our materials um, or to host us in their office. Every once in a while, law firms may agree to allow us to use their space in some of these remote areas where we don't have an office so that our attorneys can have a place to go and have confidential communications with local residents.
What are the first steps someone should take if they're considering drafting these documents?
The first step is to take an inventory of what you have. It is not uncommon for people, when I ask them to review their documents, to realize those documents do not say what they think they say. So they should get all of their insurance policies. That means your health insurance, your long-term care insurance, your life insurance policies. Look them over. They should look over any existing estate plans. They can they really should. Some of my clients, they found out that they were damaged by pests or in a flood or some other catastrophe, and their documents were destroyed. They should also gather any accounts they have with any financial institutions, such as a brokerage account, your retirement account, your pension account, your bank accounts. Make sure they say what they say, and have all of those things together and in an envelope or in a safe place, along with your marriage licenses, your deeds, because that's very important to review. Just like people review their pension statements every year, they should also review their estate plan and related documents every year, just to make sure they say what they need to say, or they may need to be updated. That's not uncommon for people to have deceased people or people they're no longer with or someone they divorced on their documents, and they realize they never changed it like they thought they did. And also, after they do that, then they should contact a lawyer for a consultation. You don't necessarily have to hire a lawyer, but you should at least consult them, because I find that by having clients consult in the lawyer, even myself or someone else first, they have an idea of what kind of things they should be doing, what kind of questions. Because the hardest part, I believe, in estate planning is not the drafting, it's on the testator or the testatrix, the person, to think about what it is they want. It's hard for some people to decide what they want, especially if they have estranged relationships within their family, if there's a lot of assets, if there's some kind of family dynamics going on. So really, they should consult a lawyer before they have anything drafted to make sure it's what they really want.
What resources are available?
There's a lot of different resources available. At least in Florida, Florida is home to a lot of legal aids or legal services agencies. I know in Orange County, you have Orange County Bar Association. You also have our office. In Brevard, you have Brevard County Legal Aid. You also have our office. In Seminole, you have Seminole County Legal Aid, and you also have our office. So that's what I'm saying. There's a lot of free legal services that's available in the area if people want to get free estate planning. And also, they also, all these organizations, in addition to our office, host estate planning clinics for free. We also have the Florida Senior Legal Helpline throughout the state. I believe the state of Florida also have a veteran helpline. So there's a lot of different agencies that's available in Florida that's for free. And if not, you can also call the Florida Bar Attorney Referral Service, and they can give you a list of local attorneys in your area who are competent in estate planning and who can draft your documents for you. And while, yes, you can draft them yourself, I want to say about at least 80 to 90% of the documents that's presented to me that was drafted by a person on their own without the aid of an attorney, I can usually immediately, within a few minutes, find legal defects that will make that document invalid or unenforceable under the law. So that's why I always encourage people, if they can, spend those couple of $100s and hire an attorney, because when they don't, it costs thousands of dollars later to try to resolve something that could have been prevented for only a few hundred.
Any final thoughts or takeaways that you would like to leave with our audience?
Yes, adequate legal planning is essential. People have to plan for life and also for death. The goal in Florida has always been to allow residents to age in place and seek an attorney early before it's too late. If someone's incompetent, a lawyer has very few options they can do to assist the person, and it can wind up costing thousands of dollars. So plan early.
All right, so I'm just going to give you a scenario here. This is an activity. It's called the Dilemma of Unclear Wishes.
Okay.
And if you could just walk us through like how you would resolve this type of situation. So in this hypothetical situation, aging parent, Mr. James Harris, falls into a coma after a sudden medical emergency. He has 3 adult children with 3 different opinions about his medical care. Unfortunately, Mr. Harris did not have an advanced directive in place, leading to confusion and conflict among family members. And the hospital needs a decision. The eldest child believes in pursuing aggressive medical treatment. Other family members represents that the middle child who wants to follow a more conservative medical approach, and the youngest child believes in adhering to religious principles. The siblings are in disagreement over the course of medical treatment for their father. The hospital needs a decision, and without an advance directive, there's no clear understanding of what Mr. Harris would have wanted. The family meeting becomes tense, reflecting a broader issue many families may face in such situations.
Well, in that particular situation, I will confirm that the person didn't make an oral statement or have a prior advance directives or some other document, because an advance directive can also be a written document outlining your medical wishes or things that you don't want. That also includes whether the person has a DNR. Even though DNR is not an advance directive, they may actually have one which can impact the treatment that they desire to have. Another thing I would like to know, or I would inquire, is to determine whether that person has an unmarried partner, because sometimes people are in long-term relationships, and there may be some other document that may outline what their wishes are, because that's something that can come into play. Another thing is too that even if it's not an advanced directive, has the person in the past communicated with family, friends, neighbors, especially if it's a recurring theme of the kind of treatment they want or they don't want. Because some people, a lot of people, they don't put things down in writing, but they may say it a lot, such as, I want to be cremated. And they may tell everyone that they want to be cremated, things of that nature. And if you can establish a pattern and that person, and you have a lot of corroborating witnesses, that would be something I would like in writing, notarized, because the family can have two choices. They can go and seek to be appointed as a medical proxy under 765. It allows the appointment of a medical proxy. The first one in the statute who get preference is a court-appointed guardian. If there's no guardian, the next person up is a spouse. If there's no spouse, the next up is the majority of the children. So that's something that will be in play also. Is one of the children or all of the children trying to be appointed as a medical proxy under the statute? The alternative is that the hospital or anyone can certainly file for an emergency guardianship, which is typically when someone has a life-threatening illness or some kind of imminent threat. You can seek to be the emergency guardian for someone who lacks capacity, and that's treated as an emergency, and you probably can get a hearing within 24 hours. And judges, they do that in Florida, throughout Florida, very quickly. So emergency guardianship may be needed, and a court will make a determination, especially if all of the kids want to be the emergency guardian, which one is in the best interest. The court may actually appoint someone such as a professional guardian or the public guardian if the father is indigent, to be the actual legal guardian for those 90 days, to make those medical decisions for him.
Wow. So you could just kind of lose all autonomy of the parent.
Exactly. And again, another thing that I would want to know is one of those children an abuser? Are they estranged? Because if they are, like he may have an injunction against them for financial exploitation or elder abuse, or they may be estranged, haven't seen him in 20 years, but here they are saying, hey, I want aggressive treatment, or I want no treatment. That will be that's something that's very important to know and for the court to know. And this is another reason why the documents should be in writing, because even if he made an oral statement, those are hard to enforce versus something that's in writing.
All right. Well, thank you so much for being here and for this information. I hope the viewers can see how important it is to have these documents.
Me too.
And where can people go to find more information?
If they want more information, they can go to www.c as in Charlie, L as in Lion, M as in Mark, F as in Frank.org. Our website has lots of information on many legal topics, including estate planning. And if they can't go there, they can always go to the Department of Elder Affairs, which has a resource hotline, which can refer them also to a legal provider that's throughout the state of Florida.
All right. Well, thank you so much for being here.
Okay, thank you.
If you're enjoying this show, please subscribe to our channel and follow our Instagram, Facebook, and Twitter accounts.